Okay, so I just wanted to wish long life to my cousins, Nikki, Lauren, and Jolene Fisher on the passing of Kay Fisher, their mom, and I want to wish long life to Kay's sister and my cousin Monty Diamond and all of Kay's friends and family. And I hope this share that we give is going to be a elevation and aliyah for the mom's neshama, and just
Right.
to wish the family long life. So before I get started, Kevin, if you want to just share one or two ideas before I get started with the Gemara share.
Yes. Okay. So, just some things on Yom Kippur, on fasting. I found some things here from the Chabad website. Always, you can't go wrong when you use Chabad. And just to repeat, even if we remember, the 5 afflictions that we take upon ourselves on Yom Kippur are not partaking of food and drink, not bathing, not applying oil and cosmetics to the body, wearing sandals. Now, I think what they meant was wearing leather sandals, as long as it's not made of leather, shoes or sandals, then you should. That's what ideally one should wear. And physical intimacy with one's spouse is also not allowed. And in terms of eating, in terms of food and drink, if somebody needs to take medication, they can ingest a minute amount of water, which is less than what's considered drinking. Because if people have to take medication, they have to. You can't just swallow medication without water. So they can swallow tablets with an amount of water that's not considered drinking. So obviously one should consult your local rov for the actual quantities. And the same applies to food. You need to eat something small to ingest a tablet. The same thing applies. It's the quantity. Okay.
Okay, so just one thing that we're going to learn before the Gemara share is basically, if you have a look, we generally learn when somebody loved has passed away, we learn a Mishnah, because the letters of Mishnah and Neshama, soul, has the same Hebrew letters, so that's where the custom developed. So if we learn in Pikei Avot, Ethics of the Fathers, chapter 4, verse 1, with Ben Zoma, it says, who is wise? A person who learns from every person, meaning that it doesn't depend on learning only from those that have got more authority than us, or those that have got higher positions or seem more esteemed. We can learn just as much from the CEO of $1 billion company as we can from a janitor, because every soul is equally created and every person has got different experiences and life lessons that they can teach us. What we have to do, according to Ben Zoma, is humble ourselves to the degree to know that we are no better than anybody else, and that everybody has got not only what to teach us, but also has got different strengths and weaknesses in areas that we might be deficient, they might have mastered. So by the same vein, Ben Zoma says, who is strong? Not one that is physically strong, but a person that subdues their inclinations. In other words, they're not driven by their base instincts and their drives. And there can be a base instinct not only of like physical gratifications, but also ego gratifications. And therefore, one who subdues his natural negative inclinations in favor of both restraint and the ability to grow and develop, where it takes a significant amount of discipline, that is considered somebody that's strong, not somebody that dominates others. And Ben Zoma says, who is rich? A person that is content with his lot. So that is often misinterpreted as somebody that is happy with achieving very little, and that's certainly not the case. What Ben Zoma is saying, when one is happy with one's lot, it means that we accept that Hashem has given us certain challenges in our lives to overcome, and not to be jealous of the next person that seems to have more, or seems to have an easier time, or seems to acquire things easily compared to the struggles that we have. Meaning, we have many blessings, and sometimes there are things that are lacking in our lives, at which case we must be satisfied with the fact that there are many blessings, even amongst the challenges, and not to see that as a point of acceptance that we cannot achieve more or have a certain amount of self-betterment, but merely that you enjoy each and every day for the simple blessings like being able to see and walk and going in a garden and looking at nature and enjoying things that don't necessarily take a lot of money, but merely an appreciation of just being able to have our bodily faculties, our mental faculties, and simply being alive is a privilege. So whilst we can strive for goals, if we're not satisfied with what we have, we're certainly not going to be satisfied when more is given to us. An ungrateful person is not given more because they don't even appreciate what they have, according to Ben Zoma. And who is honored? One who honors others. In other words, instead of being focused, if you've gotten enough acknowledgement and personal accolades, and people have shown you the right amount of respect, people have acknowledged you, a person that contributes to the lives of others. And Kay was very much such a person that dedicated her entire life to her daughters, and just was such a giving person that is somebody that is honored, that sort of quality of person that looks after others and is a contributor to others instead of figuring out what others owe them. And if we can all be like that and look at the needs of others and service those needs, that is a person that is honored by Hashem, the Creator. So just before we get into the Gemara share, of which we do every day, I just want to give a bit of a sense to those that are listening that are not generally aware of what's involved with various Gemara tractates. Somebody asked me today, what actually is Bava Kamma? So Bava Kamma is one of the tractates of the Talmud, which is a central text in Rabbinic Judaism that consists of both the Mishnah and the Gemara. So basically, Bava Kamma, what we learn every day, is a tractate that deals with Nezikin, which is damages, and it's the order of the Mishnah that's primarily concerned with civil law. And this particular tractate that we're dealing with focuses specifically on the laws of damages and torts. So Bava Kamma is the first of a series of 3 tractates known as the Bavot, which include Bava Metzia, which deals with acquisitions, and Bava Basra, which deals with property law, etc. So roughly it's translated Bava Kamma as the first gate, and it indicates its position as the first of the 3 tractates in the series. And there's a variety of topics that are related to damages, including, for example, you've got what you call the types of damages. And in those days, you were dealing with mainly a agrarian culture where you had animal husbandry and livestock and plants, etc. You weren't exactly dealing with 21st century industrial technology. So one might ask, why you study those old laws? And the simple reason is very simply that it serves as a framework for the detailed discussions of damages that can occur in the various subcategories. So whether you had in those days an ox that would come and damage your property, or now somebody reverses their Mercedes into your wall, you're dealing with human nature. And human nature is such as that it likes to negate any responsibility for wrong action. So it doesn't matter whether the technology's changed. Human nature is human nature. If you look at how Bava Kamma relates to civil law is that South African law is based on Roman Dutch law and English law. English law came from Saxon law, which was Roman law. And the Romans would absorb different cultural strengths. Amongst the Greeks, they took certain aspects of physics and mathematics and geometry, etc., etc. And amongst Judaic culture, what they took was a very sophisticated law system, which consisted of civil and criminal law, which was the Talmud itself. And if we have a look at what it dealt with, is one of the issues was liabilities, is that it delved into the complexities of determining liability in various situations, including the different levels of responsibility that apply to an individual depending on the circumstances of the damage. So when you're dealing with damages, what are you dealing with? You're dealing with compensations primarily, because it outlines, Bava Kamma, how they are to be, number one, assessed, and what kind of compensation is owed to the injured party. Can consist of everything from medical treatment, the value of lost work, and other forms of restitution. Then you get to a higher level of punitive damages, which consists of prohibitions and fines. Because beyond simple compensation, the tractate, guys, also deals with cases where additional fines or penalties are imposed. For example, in some cases, you could have a person that causes damage, and the reason that they're required to pay double the value or full value as opposed to half value has to do with other factors, such as knowing that the property they have would cause damage. In other words, you might have had an ox that was warned various times, according to the damages they did both to people and property, that this is a very dangerous animal, and keeping that animal would require a certain amount of extra special care. And if one is deficient after being warned, they're subject to full penalties as opposed to partial. Well, full compensation as opposed to warnings and partial compensation. Penalties have to do, Gavin, with a much more stringent sort of basis, and that is when one actually breaks the law. So, for example, when one steals, then the full force of the law goes against them. Mercy is generally shown if it's a once-off offense, if it's a case where there's circumstantial evidence and not enough witnesses, cross-testimony of witnesses can be a little bit suspect, etc. So all of these are factors that are taken into the consideration. One of them is self-defense. For example, the rights of individuals to protect their property. And we're saying what conditions will exempt a person from paying damages if they were acting in self-defense. So we all know that when we dealt with Sanhedrin is criminal law cases, that you have a case of a roy death where somebody's coming to kill you. And in that case, absolutely you can defend yourself, even at the cost of killing them. And even if you see person A chasing person B in an attempt to kill them, person C can intervene, even if person A is killed, because they are a predator and somebody else is running for their lives. However, the first obligation is to try and see if one can maim instead of kill, and do everything possible to stop an assailant before the damage becomes one of homicide. And in terms of interactions, a Jewish person is as responsible to look after their fellow Jews as non-Jews, because at the end of the day, the ethics are that if money is borrowed, it has to pay back. It has to be paid back. If damages are occurred to both a Jew and a non-Jew, a Jew's obligation is that he has to treat every human being as if he wants to be treated in the same manner. So, in other words, borrowing money, it has to be paid back. You damage somebody's property, you have to pay it back. So the issue in terms of Jewish and non-Jewish are the same in terms of a Jew's responsibility. However, other financial issues like charging interest, etc., Jews do not charge other Jews interest, specifically because they cannot make any profit in a case where money lending is involved, because it said you have to live side by side and try and see if you do not impoverish your brother further with interest tables. So in many cases throughout history, Jews were prevented from owning property or conducting in normal merchandise and commerce. And then many of them were involved with banking and interest levels, etc. Additional topics that were covered, if you remember, in terms of civil damages, were issues regarding taking oaths and the responsibilities of watchmen and the laws of robbery and theft. What we mean by watchmen is there's different levels of responsibility. If somebody was a paid custodian and they were paid to look after your goods, they share a higher responsibility because they gained a financial benefit, as opposed to when you borrowed an object from somebody and they were doing you a favor. So the more of a favor they're doing you, the more responsibility you're taking on. And the more you're doing them a favor, the less responsibility you're taking, especially if you're an unpaid custodian and somebody says, just look after my dogs and my property and feed them while I go to Australia. If you're going to be sued as a result of not doing an adequate enough job and you're not getting paid for it, you're certainly not going to want to take on that responsibility. So the amount of responsibility is directly in proportion to who's doing whom a favor. So like all tractates, it's not just a dry legal code, but actually includes a mixture of legal discussions, ethical teachings, stories, debates, etc. The reason why there's a debate with the principle of the law is we want to know, with the complex issues, where the law applies and where it's stretched out of proportion, where the constraints no longer apply, and the limitations. So if you wanted to know, when we said that Bava Kamma deals with both issues of damages and torts, and you want to know what torts actually means, it basically refers to a civil wrong that causes harm or loss to somebody, leading to legal liability for the person who commits the tortious or act. We don't mean torturous, but tortious. So unlike criminal law, in a case where the state prosecutes somebody for a violation of criminal statutes, because what happens in criminal law is you've done a crime against the country or against the state. Tort law is typically enforced through civil litigation. And it has to be initiated by the plaintiff, in other words, the injured party. So the primary objective of tort law is to provide relief for the damages incurred and deter others from committing the same sort of harms. But there has to be a case where either the individual or a company takes legal action against the defendant and not the state. So if you have a look at categories of torts is mainly civil law, to almost right the wrong. You're dealing with the case number one of negligence. So that's the most common category, and occurs when a person basically fails to exercise the level of reasonable care expected of somebody in a particular situation. So all we're saying is that there has to be an amount of reasonable responsibility. And therefore, if you're causing harm to somebody else, like car accidents due to reckless driving, medical malpractice, and slip and fall cases, they're often due to negligence. So it's not intentional, but one has to take a certain level of responsibility. Then there's intentional torts, and that category includes actions that are intentionally harmful. You're looking at assault and battery cases, defamation, fraud, false imprisonment. And then you've got an issue of, I'll give you an example of where intention does make a difference. If you have a look at Sanhedrin, where you are dealing with a case of criminal law, there is a difference in the case where a husband comes home and finds his wife having an affair with a best friend. And when he empties 6 bullets out of his revolver and ventilates his best friend, obviously he's going to do time. But the court can understand that if he walks in on a situation where his wife's having an affair with his best friend, he's liable to do something impulsive. So that might bring a bit of a more lenient sentence than a person that conspires with somebody else's wife to get an insurance policy and knock off the husband, and the wife and him go off to Mauritius together to live happily ever after. Because the one has got malicious intent that it requires premeditation and full planning, and the other one is an impulsive reaction to a situation. Neither is condoned, but mercy is shown in the case of impulsiveness compared to premeditated homicide or assault. So intention certainly does count in terms of law. We also stated that there's an issue of strict liability. So this involves situations where liability exists regardless of intent and negligence. So in other words, intent or negligence is not taken into account. If you're looking at strict liability cases, they generally apply to activities that are inherently dangerous. I'll give you an example. You're using explosives or keeping wild animals as pets. So then it doesn't matter if you weren't negligent or you didn't have ill intention. The very fact that that animal is prone to be toxic means that it's drama looking to happen. So let me just give you some elements of a tort. So for a tort claim to be valid or a civil legal case, certain elements generally need to be proven. Number one, duty. What do we mean? The defendant has a legal duty to act in a certain way toward the plaintiff under circumstances that are deemed reasonable by not only according to contractual law, but the general civil law within the country. So what happens generally with civil law is that cases are put forward based on hundreds of years of studying of human behavior, where many of those cases have occurred before in different ways and forms. Society, in order to not end up in anarchy, has to have some regulation. So what law generally consists of is two attorneys, both for the plaintiff and respectively for the defendant, bringing a case forward to show that legal history has been on their side, and the case that they bring both has to be as suitable as possible to the case between the defendant and plaintiff in order to hold weight of having legal precedence. Then we've got this issue of breach. So the defendant breached the duty by failing to act appropriately, by impinging on the rights of others. Then we've got causation. What's that? So the defendant's action or inaction directly caused the plaintiff's injury. So what do we mean action? Well, action is when you reverse a car and hit somebody else. Inaction can be a case of what you call negligence. So, for example, there was a case in South African law, unfortunately, that there was a institution that looked after people that were mentally handicapped and suffered from dementia, and it wasn't primarily frail care. It was mentally ill patients, generally schizophrenia, dementia, etc. And the caregivers failed to feed or medicate these patients correctly, and many, many patients died. So that's what you call not a case of an action, but inaction. Inaction is negligence. Inaction is the failure to do actions required to sustain the health, life, or good living conditions of an individual you're responsible for. So inaction can cause as much problems as action. I think that's pretty clear. So there's cases of defendant's action, in other words, active damage or inaction, that the failure to act has caused the damage. Then you've got, what do we mean by damage? It means that the plaintiff suffered some kind of harm or loss as a result. It could be reputational, it could be actual, it could be a loss of opportunity, etc. And we're looking at the remedies. What are the remedies in the form of monetary compensation or damages, such as compensatory damage? So we have a case where reimbursement to actual harm and loss, that's compensatory. Then you've got consequential damage. So that's reimbursement for additional harm that actually are a direct result of the initial harm. So, for example, you hit somebody's car out of negligence, and that person missed a flight. Then your initial action was a catalyst for them missing their flight and a whole chain of events, etc. So how far can you carry that? Well, the law also has limits. You can't say that that flight was meant to get you on a job interview and therefore you lost out on the job interview and therefore they're responsible for a year's worth of wages. It's got to be within reasonable amounts. So, for example, the car accident and maybe what the aeroplane ticket would cost. But in terms of what couldn't possibly be, there's no way to equate that that person necessarily would have got the job on that interview. So it has to be within certain constraints. Then you've got punitive damages, and these are, I'll give you an example, additional damages intended specifically to punish the defendant for egregious behavior and deter others from a similar content. Like, I'll give you an example. What you're dealing with is sometimes you'd have a defendant that has a case of ducking and diving for fraud and putting the plaintiff through hell by making false oaths and saying, I never took it, and there weren't adequate witnesses, and eventually adequate witnesses come to light. Because they have used the law to sometimes circumvent due process, they are punished with certain penalties. So, for example, if you've got a person that studies the law and has a contract and they say failure to fulfill this contract exactly will result in non-payment. So obviously nobody's perfect and they can't fulfill the criteria because it's just impossible. This person has used the law in order to have the pretext not to pay. So those sort of punitive actions are also taken into account. In other words, they have absolutely wasted the individual's time as well as the court time. So in some cases, courts may also issue injunctive relief to prevent future harm. So what they do is they can punish a person as a precedent to almost show that this sort of behavior won't be tolerated. So tort law varies considerably between jurisdictions. We learned both in Sanhedrin and Bava Kamma that you've got municipal courts, you've got city courts, you've got courts within Jerusalem, you've got high court and Supreme Court matters. And what constitutes a tort in one legal system may not be treated the same way in another. However, guys, the fundamental principles of duty, breach, causation, and damages remain relatively consistent across different legal systems. And you can see this whether you study Talmudic law or law in most countries, is that they're based not only on case studies, but hundreds of years of human behavior to basically constrain those that do not act properly from getting out of hand, and also to make sure there's restitution from those that towards those that have acted properly. So guys, we're not going to go through the standard share that we do every day in this particular case. We almost finished Bava Kamma. What we were dealing with in Bava Kamma, as you know, is if children inherited an item that they borrowed, what's the level of responsibility to the original owner? And there were cases of unavoidable mishaps compared to actual human intervention that created damage to that property. All right, guys, I know you've had a long day. Really, really appreciate it. I wish long life to my cousins, and just, guys, thank you very much.
Damon, is this your mom's sister?
No. When I say the word aunt and cousin, Kay is actually related to us because my cousin Leslie, so Leslie's mom was my grand sister. So Kay married Leslie Fisher. So it's a cousin through marriage, so to speak. We always grew up calling people aunts and uncles and things like that. But it's actually my cousin's, my late cousin's wife, Kay. And then, so we related on that side, and Colin Diamond and Monty Diamond are cousins on my father's side. So the families know each other quite well. just thank you very, very much.
Yeah.
And Kevin, thanks for teaching us.